So we'll get rolling with our first speaker of the whole conference. It's my great pleasure to introduce Professor Joanna Erdman, who's the inaugural MacBain Chair in Health Law and Policy at the Schulich School of Law, Dalhousie University. Joanna's research focuses on sexual and reproductive health and human rights in a transnational context. She's acted as an intervener before various constitutional courts and international bodies, and as an expert advisor with the World Health Organization. Joanna holds a JD from the University of Toronto and an LLM from Harvard Law School, and completed a fellowship at Yale Law School. Joanna's going to be speaking to us this morning about abortion rights in public places.
Great, thanks, and it's okay to speak from here?
Yes.
Great, all right, I've got all of my instruments. Perfect, well, thank you so much, and it's great to be with everyone today, and thank you to the organizers. I'm going to present on abortion rights in public spaces, and from the perspective that with a view to the US, there has been really a renewed interest in Canadian abortion law. And it's an interesting interest because Canada is known as having no abortion law. And when the recent Trudeau government proposed one, an abortion rights law, abortion activists campaigned against it. And so I think this is an important moment for us because it really asked, what is an abortion law and what could it be? And is there an abortion law to which we would have said yes? Because in truth, we do have abortion law in Canada. There's been quite a bit of abortion lawmaking around access zones. So these are laws that prohibit protests and other activities around the people and the places of abortion care. British Columbia enacted the first statute in 1995, and then for more than 2 decades, there were no provinces that followed. In 2016, Quebec and Newfoundland did, and then there was Ontario, Alberta, Nova Scotia, and then just recently in 2023, Manitoba. So what are these abortion laws? They're basically legislated injunctions, and I think the term injunction is important because it names their origins. They were first private injunctions, which were granted to abortion clinics, and they were later public injunctions. And in Ontario, the Attorney General had to defend this public injunction against constitutional challenge. The case was called Dealman, and many people don't read this judgment. It is hundreds of pages long, but it's a really important judgment because it's a deliberation on the law of injunction, zoning power, and abortion rights. And it sets abortion rights in the context of freedom of expression and assembly and the right to protest. And then in a case called Lewis, the BC court really relied on Dealman to, again, declare the first access zone statute constitutional. And then there was a legislative blueprint for all the other provinces. So I want to say that these are abortion laws that are worth their name, and we should name them. Canada does have an abortion law. These are important for a few reasons. The first is because all of these laws are post-Morgentaler. And so all of them are self-consciously abortion rights laws. But because they intersect with freedom of protest and public space, they don't just reflect the Morgentaler right, they really build on it. The second thing about these laws is even in their contemporary drafting in 2023, they still reflect the context of their origin. And so what is that? That's the 1990s in Canada, when the site of abortion care shifted from hospitals to freestanding clinics. And I think also these statutes reflect the cultural and political ideas of the clinic, especially care politics. And so in this paper, I've put together these two ideas, which is that these laws express care politics through the regulation of public space and the power relations that overlay it. And so these are about abortion rights in public spaces. And I think that's a fascinating way to think about abortion law in Canada. And especially because zoning as a police power is not something we usually associate with liberatory projects or justice. And so I also think these laws sit in some tension, if you like, with the renewed interest in protest politics in abortion activism worldwide. So this discomfort with the laws is where I start my study, and it's really a discomfort with abortion rights being site-specific, which is what these laws do. There's this kind of specificity to the law. Access zones are land-based. They are marked by 50 to 150 meters in length. Clinics are separated from facilities. Facilities are itemized as hospitals, doctors' offices, health centers, pharmacies. Doctors and other health professionals are isolated from all other care providers. Persons who use abortion services are only named as patients in the statute, and any person who accompanies them is also named a patient. So patient-provider is the only care relation in this statute. And then the statutes, very interestingly, only protect lawful abortion care. So the reason I name all these real details of the statute is because this is classic of the zoning power, the separation of space between permitted and prohibited uses. Protest is prohibited, but these laws also contain abortion care. And so from this view, and I put this image on the slide, the statutes don't look so different from criminal abortion laws, quite frankly. We've always carved out space for legal care by the places, the people, the practices of care. If you remember that famous line by Trudeau Sr., who said, "There's no place for the state in the bedrooms of the nation," but he did it when he was criminally confining legal abortion to hospital settings. So there is this use of arbitrary numbers, a use of institutional archetypes to really allow some, but not too much, reproductive freedom in these statutes. So I'm not the only one who noticed that there is this relationship between criminal law and these zoning laws in abortion rights. In this R.V. Lewis case in 1996, when the court upheld the first access zone statute, they also noticed this link. So the Supreme Court of British Columbia here began its analysis, and this is interesting, I think fascinating, with the 1969 criminal law in Canada. But how they named that law, how they described it was quite distinct. They said, this is a law where Parliament permitted a doctor to perform an abortion in a hospital. And so the court reads the criminal statute here as actually a health statute that promised but failed to deliver care because there were too few hospitals, they were too far away, and they made practice illusory. And so the constitutional failure of the law was in healthcare access, and the remedy of the law, therefore, on this court's retelling of Morgentaler was to, quote, open the way for other facilities to provide care, namely freestanding clinics. And so the clinic is freestanding, the court says, only because it was filling for the limitations of hospitals. But the clinic is absolutely a place for caregiving and care receiving, making protest inconsistent with these care functions of the clinic. And so for me, this means that the site specificity of these statutes is not a controlling logic. It works differently. What it does is to name and make certain the places of care. It is a right to a reliable and a functioning healthcare system. And in Dealman, the Attorney General defends the public injunction on exactly this basis. They say, abortion is a public interest when, in fact, we cannot ensure services to access. In other words, access zones protect certain rights of access. And I think this is really significant. Services to access, not just access to services. But like many zoning laws, the statutes today are hopelessly out of date. You might not know this, but there is now only one freestanding abortion clinic in all of the Maritimes, and yet there is better access in the region than there has ever been. And the reason why is because abortion care, when it truly integrated into the healthcare system, it disappeared from sight. After 2017, the map looks very different. And it's because abortion with pills are now accessed by remote communication, mail delivery. There are thousands of primary care settings, all the way including the comforts of the home. So I think the question for us is, have we zoned out? Yeah, there's a discourse in global abortion politics around abortion beyond borders, beyond law. And so maybe also here beyond the site specificity of these statutes. But I don't think so. I think these statutes still have a lot of relevance for us. And it's because the statutes work with multiple senses of space. Absolutely, they talk about healthcare as specific sites of care, but there's also a social spatiality to these laws. They're connected to spaces outside of the physical provision of care. And these spaces, they may lack physical form, but they have this real perceptible presence. They have an influence on people's access to care. In the laws, again, in their preambles and their objectives, they talk about protecting a right to access in an atmosphere of security, privacy, and dignity. This is, again, really significant about what these abortion laws do. They make a connection between the external effect of the law, the prohibitions on protest, and an internal affect of the law. What they're doing is they're allowing certain sensory experiences to come forward, and they're suppressing others. And you can see this, again, in the specificity of their prohibitions. They target acts of disapproval, dissuasion, condemnation. So how did the courts justify these atmospheric access zones? Well, in many cases, they returned to abortion care as healthcare. They said, look, patients are vulnerable when they enter health clinics. Anxiety, distress, discomfort, those are health-related risks. They emphasize these aren't the same kinds of sites of ordinary political protest. But the thing is, now they are. Because just as much as the siting of abortion care has changed, so too the sites of protest has changed. And now protest is happening outside high schools. It's happening through advertisements on city buses, graphic postering on streets. But cities have struggled to protect public space the way that the provinces protected clinics. In fact, there's only one Alberta Court of Appeal judgment that reasoned differently. They said, hey, access to a safe and welcoming transit system is a valid government objective. So the case struck me because I thought about some reasoning in the Dealman case that also tracks this idea of understanding public space distinct from a healthcare site. And maybe it's because Dealman is a case about a public injunction. And so it, again, reasons from public space. It reasons from law of nuisance, the right to use and enjoyment. And so here, abortion rights are not about fences at all, as per the Morgentaler judgment. They're really about the freedom to be in public space. It's a freedom to use public resources. It's the right to ride the bus and the right to walk the sidewalk. And when you do, it's the freedom from the entitled evaluation and the observation of others, from being known to them and made available to them. This is a freedom not just to make decisions about your own body, it's a freedom really to live freely in your body. And so it's a right of security of person in public space. And again, in abortion research, people who made the decision to end their pregnancy in contexts of violence, they were the people who took most notice of clinic protest activity. I think there's this connection between public violence and state violence, and that's the only way the courts in these access zone statutes can come close to articulating the kind of harm that this abortion law addresses. In these judgments, the courts ask, how can there be an abortion right against state but not public violence? And so they make the connection between the two. This idea of abortion criminalization as the sanctioning of reproductive violence, this idea that there is a cascading effect from state action to normalized violence in everyday life, this is now the discourse of abortion protest activity globally. In Latin America, for example, they are not claiming just a right to their bodies. They are taking to the streets in large-scale mass demonstrations, and they are arguing for aborto libre, free abortion. And they mean abortion in public spaces. And so this is a discourse that rejects absolutely abortion rights as just healthcare rights. It rejects this idea that you protect abortion rights just through a narrow government agenda of service delivery. And so it might seem like it's a world away from these access statutes, but I actually think it's not. And the reason why is because if you look back to the origin of these access statutes, the origin is the freestanding abortion clinic. And what did that clinic do? It put abortion street side. It put it in the public sphere. It did so in a commitment to care for and to take care of people, and it did it even when the state prohibited it and a public denigrated it. And so I think the abortion clinic was the first act of public protest. And by its protection by public and later these legislative injunctions, especially in the 1990s in Canada, when otherwise you had massive retrenchment in social policy, this was the moment when governments took on the care politics of the clinic as their own. And so in conclusion, I absolutely think that Canada has an abortion law. It is these statutes. This is our law. And the significance of these laws is that they absolutely reframe the public space as not just a space for opinion formation and expression. No, they frame the public space as a space to take care of people in conditions of structural inequality. They are absolutely about protecting the use and enjoyment of public resources for reproductive health and living. And so I think this is a law worth calling a Canadian abortion law. And I think it's a law that maybe we would agree to in the future again. So thanks very much.
Super. Super. Notre prochain conférencier, c'est Véronique Pronovost. Elle est doctorante en sociologie et études féministes à l'UQAM. Elle s'intéresse à l'antiféminisme conservateur aux États-Unis et au Canada. Plus spécifiquement, ses recherches doctorales portent sur le mouvement contre l'avortement aux États-Unis. Elle est membre de divers groupes de recherche et elle est impliquée auprès de plusieurs groupes féministes du Québec.
Bonjour tout le monde. Ça fait déjà une dizaine d'années que je m'intéresse au mouvement contre l'avortement aux États-Unis. Par la force des choses, j'ai fini par m'intéresser à ce qui se passe au Canada et au Québec aussi. Mais donc aujourd'hui, je suis ici pour vous parler d'une petite partie de mes recherches doctorales sur le mouvement contre l'avortement aux États-Unis. Donc la présentation va être divisée en quelques sections. Je vais d'abord vous présenter un petit peu le projet de recherche, ensuite la méthodologie que j'ai employée, pour la simple et bonne raison que ce n'est pas une méthodologie tellement conventionnelle. Et ensuite, on va entrer dans le cœur du sujet sur les conflits qui prennent place au sein du mouvement contre l'avortement. Donc, pendant cette dizaine d'années, évidemment, j'ai pu prendre la pleine mesure de l'ampleur de la littérature qui existe sur le mouvement contre l'avortement aux États-Unis et j'y ai remarqué certaines limites ou certaines questions, en fait, qui suivaient mes lectures. Et donc, premièrement, peut-être un enjeu définitionnel, c'est-à-dire qu'on a tendance à confondre les différents concepts comme la droite chrétienne, le mouvement contre l'avortement, le Parti républicain, et on va en venir un peu à faire une assimilation de ces différents termes, de ces différents groupes. Et donc, pour moi, c'est important de venir essayer de voir où ça commence, où ça finit, ce mouvement contre l'avortement. Aussi, la majorité des recherches vont se concentrer sur les institutions politiques et judiciaires. C'est-à-dire qu'on va voir comment le mouvement se déploie au sein de ces différents espaces, au sein de ces différentes institutions. Mais évidemment, un mouvement social, ça ne s'arrête pas aux institutions formelles. Et je trouve qu'il y avait une lacune là-dessus sur les aspects plutôt culturels et le reste, en fait, de la société où ce mouvement se déploie et parvient à réaliser des gains autrement que via la politique. Et finalement, le dernier aspect que j'ai remarqué dans cette littérature, c'est qu'on a tendance à vraiment avoir une perspective d'outsider. Évidemment, ce n'est pas un milieu qui est nécessairement facile à percer, donc je comprends la posture. Et la majorité des recherches vont emprunter une lunette théorique du contre-mouvement. Très rapidement, la théorie des contre-mouvements, ce que c'est qu'on va observer un mouvement social et son mouvement opposé, donc le contre-mouvement, et on va vraiment observer cet effet de balancier, en fait, où un mouvement social va réussir à parvenir à faire des gains, qu'ils soient réels ou perçus, et donc ça va générer une réaction du mouvement social opposé, et on va vraiment se retrouver dans une situation de balancier. Et donc, c'est vraiment dans cette perspective très relationnelle, donc entre les deux mouvements, que la majorité des recherches sur le mouvement contre l'avortement vont avoir lieu. On va observer les conséquences de la présence du mouvement contre l'avortement sur les mobilisations, sur les choix stratégiques, par exemple, du mouvement pro-choix. Et donc, je me disais, c'est hyper intéressant, évidemment, dans cette logique dialogique et relationnelle entre les mouvements. Mais bien évidemment, il y a des lacunes importantes quand on veut observer ce qui se passe à l'intérieur d'un mouvement social. Hein? La théorie des contre-mouvements, un de ses effets, c'est de vraiment venir réduire, simplifier, homogénéiser les deux blocs qui s'opposent finalement. Et donc, on ne parvient pas à voir ce qui se passe à l'intérieur de chacun de ces mouvements sociaux. On ne parvient pas à aller voir la complexité, la diversité, mais aussi l'hétérogénéité qui existe au sein de ces mouvements. Et c'est donc dans cette perspective-là que j'ai décidé de créer ce projet de recherche doctoral dans le but de créer un portrait du mouvement contre l'avortement à travers différents indicateurs comme les acteurs, les ressources et les stratégies, mais aussi de comprendre les relations entre les différents acteurs qui composent le mouvement, donc que ça ait des relations de collaboration, de coalition, mais aussi les tensions et les conflits. Et finalement, bon, on n'en parlera pas trop aujourd'hui, mais contribuer au développement d'une méthodologie alternative pour étudier les mouvements sociaux réactionnaires, antiféministes, racistes, transphobes, etc. Et donc, comment ça s'est développé pour moi? Eh bien, si je voulais emprunter une perspective d'insider, il fallait forcément que je me rende sur le terrain. Et donc, je suis allée m'installer pendant près de 4 mois en Floride avec un faux nom où j'ai fait une recherche participante cachée. Donc, les personnes ne savaient pas que je les étudiais. Il n'y avait pas de consentement ou rien de ça. Et mon objectif, c'était vraiment de participer à la quotidienneté du mouvement en tant que tel. Donc, qu'est-ce que j'ai fait? Ben, j'ai participé à environ 45 événements en 4 mois. J'allais à l'église à tous les dimanches. J'ai fait partie de groupes d'études de la Bible. Je suis allée à des congrès nationaux au sein de deux autres États à l'extérieur de la Floride. Donc, j'ai vraiment essayé de m'insérer dans ces différentes sphères autres que le politique. Donc, à travers, par exemple, les activités plutôt religieuses, mais aussi les services qui sont donnés à travers toutes les organisations communautaires directement sur le terrain. Et dans l'optique de voir jusqu'où ça allait, je suis aussi sortie un peu de ce mouvement-là pour voir justement les liens avec peut-être d'autres mouvements sociaux. Et dans ce cadre-là, je suis notamment allée dans un gun show qui est finalement une espèce de marché aux puces où on vend des armes à feu pour voir est-ce qu'on retrouve là aussi la présence de discours contre l'avortement. Et ben, la réponse, c'est oui. Donc, les conflits, je suis contente, j'ai fait ça vite. Donc, les conflits, en fait, on en retrouve plusieurs à l'intérieur du mouvement contre l'avortement. Et j'ai vraiment cette impression que si je n'avais pas adopté la posture que j'ai adoptée en allant à l'intérieur, je n'aurais pas pu avoir accès à ce type de données-là. Et donc, notamment, une grande diversité, une grande hétérogénéité en termes de revendications. Donc, encore une fois, quand on tend à lire ou à entendre des choses sur le mouvement contre l'avortement, on va avoir l'impression que toutes les personnes, elles sont contre l'avortement, on veut mettre fin à l'accès, rendre cela complètement inaccessible. Mais il y a, encore une fois, il faut voir le mouvement contre l'avortement comme un spectre et non pas une seule position. Et donc, les personnes vont se positionner sur ce spectre de différentes manières. Et donc, par exemple, on ne va pas avoir la même opinion sur les interdictions totales, les interdictions à partir de 6 semaines, 15 semaines. La même chose au sujet de ces fameuses exceptions qui sont en place depuis déjà, bien avant 1973. Et donc, justement, on va vraiment venir avoir des positions très, très différentes sur ces aspects. Même chose sur la judiciarisation des personnes enceintes, cette revendication-là de judiciariser, de pénaliser les personnes enceintes qui ont recours à l'avortement, elle est davantage portée par la classe politique, bien plus que les personnes qui sont sur le terrain et qui sont finalement les militants grassroots. Et on va même utiliser des discours d'altérisation en disant ben, ces personnes-là, en fait, elles ne font pas partie du mouvement contre l'avortement. On ne les reconnaît pas comme faisant partie de nos groupes et de notre mouvement social. En termes de stratégie déployée aussi, là, il y a certaines tensions au sein du mouvement. On pense par exemple à l'action directe qui fait partie de l'histoire du mouvement contre l'avortement là, depuis les années 70 facilement. Et il y a toute une partie du mouvement qui se professionnalise, voire qui se médicalise. Et donc, à leurs yeux, l'action directe devient une menace pour la légitimité et la crédibilité du mouvement aux yeux du public. Et donc, les personnes qui vont aller, par exemple, déranger les cliniques d'avortement en allant faire des sit-ins, par exemple, ou ce type d'action, eh bien, on va avoir tendance à les voir d'une manière plutôt péjorative au sein du mouvement, justement parce qu'ils viennent nuire à ce qu'on essaie de créer au sein de l'opinion publique, c'est-à-dire de générer de la sympathie et de générer aussi un sens de reconnaissance sociale du travail qui est fait par le mouvement contre l'avortement. Et c'est la même chose pour les personnes, ça va aussi loin que, par exemple, des personnes qui vont seulement prier devant les cliniques d'avortement, qui sont aussi, par certaines personnes au sein du mouvement, mal vues, parce qu'encore une fois, on vient déranger, on vient faire des activités qui sont perçues comme étant protestataires, et les activités protestataires sont de moins en moins bien vues par nombreux militants, militantes. Finalement, il y a aussi la question de la place des femmes qui ont avorté. Et là, je parle de femmes parce qu'au sein du mouvement, on s'intéresse très, très peu aux hommes trans et aux personnes non-binaires. Et donc, quelle place ont ces femmes au sein du mouvement? elles vont être reçues avec énormément de méfiance, elles vont être reçues, par exemple, et là j'ai un exemple très, très concret, je voulais aller faire du bénévolat au sein d'un organisme, donc un Pregnancy Center, un de ces centres d'aide à la grossesse, et on m'a clairement dit que comme j'avais vécu moi-même un avortement, il fallait que je passe par un programme, donc un post-abortion group, donc un programme de 6 semaines extrêmement intense pour s'assurer que j'aille finalement l'éducation, la sensibilité nécessaire et évidemment que ma relation avec Dieu soit bien réaffirmée avant de pouvoir aller militer au sein d'un groupe comme celui-là et d'intervenir auprès des femmes enceintes. Donc, les églises ne réagissent pas de la même manière. Par exemple, du côté catholique, on est vraiment plus réfractaire vis-à-vis les femmes qui ont avorté. Elles n'ont pas beaucoup de place encore à ce jour. Quand on parlait d'avortement au sein des activités de mobilisation ou de networking auxquelles j'ai participé, quand on parlait d'avortement, on baissait la voix. Donc, il y avait des indicateurs comme ça que le sujet demeure extrêmement tabou. Et on commence à peine à faire des groupes post-avortement au sein des églises catholiques. Et chez les évangéliques, c'est beaucoup plus décomplexé. La femme d'un pasteur était allée dans une école secondaire devant 700 personnes, aller parler de sa propre expérience d'avortement. Et donc, l'objectif, c'est vraiment de ramener ces femmes vers l'Église, de ramener ces femmes vers les bons choix, la bonne moralité et s'assurer qu'elles n'auront pas recours une deuxième fois à un avortement. Ensuite, il y a la question de l'attitude. Et donc là, on fait affaire avec, c'est quelque chose qui est peut-être moins mesurable, je dirais, mais que j'ai quand même pu observer, qui est cette idée d'être be the light, be the testament. Et donc, dans ce cas-là, on veut vraiment que personnellement, on incarne les valeurs et la morale qu'on essaie de mettre de l'avant. Et là, ça va être vraiment tous les discours sur l'amour, hein? Love is ending abortion. Et donc, on va vraiment incarner la posture que l'on souhaite voir se développer dans la société. Et au contraire, encore une fois, c'est davantage la classe politique qui va emprunter cette attitude-là, mais cette attitude de guerre, en fait, et de représenter un soldat de l'armée pour la vie, finalement. Et donc, encore une fois, beaucoup de différences dans ces interprétations du rôle des chrétiens dans le mouvement contre l'avortement et dans la société en général. Et finalement, et c'est celui sur lequel je vais axer peut-être un peu plus, parce que ça m'apparaît comme étant porteur pour la suite des choses, c'est la question de la responsabilité du filet social. Et donc, qui doit s'occuper des familles? Qui doit s'occuper de soutenir finalement les communautés et les parties de la population qui sont les plus vulnérabilisées? Et d'un côté, bon, évidemment, hein, une grande majorité du mouvement contre l'avortement, comme ce mouvement repose sur une idéologie essentiellement conservatrice, milite en faveur de la réduction de la taille de l'État, milite pour une diminution des dépenses et donc forcément n'est pas du tout du style interventionniste là, de vouloir développer plus de politiques publiques. Et donc, dans cette mesure-là, la grande majorité du mouvement va militer en faveur du rôle de la communauté et de la charité pour soutenir les besoins des familles et des personnes plus vulnérabilisées. Et au contraire, on se retrouve avec un autre discours qui est une deuxième position qui est très minoritaire, mais qui est en faveur de l'adoption de politiques publiques. Ici, je vous ai mis une citation, c'est le président d'une organisation, d'un regroupement national là, de Pregnancy Centers. Et donc, cette personne-là nous dit finalement que les Pregnancy Centers ne suffisent pas pour justement répondre aux besoins de la communauté. Ça va comme suit. Donc, the pregnancy center community cannot be the response to Roe. There is just not enough of us. The response to Roe are people in the pews. Life decisions need life support. Each and every person sitting in a church is someone that the community needs. Et donc, ça fait aussi écho avec toutes les dissensions, tous les conflits qui existent entre le mouvement et les églises. Hein. On aurait tendance à croire de l'extérieur que tout ça est un mariage très heureux et harmonieux, mais pas du tout. Il y a énormément de critiques qui sont adressées à l'Église comme étant des lieux de mobilisation manqués, finalement, où il y a énormément de gens, mais très peu d'actions qui sont menées pour soutenir les communautés. Et donc, cette fameuse deuxième position que je vous disais, elle est minoritaire, elle est davantage portée par des femmes et des femmes racisées qui travaillent au sein des communautés et qui offrent des services au sein des communautés racisées et vulnérabilisées de manière plus générale. Et donc, on va reconnaître jusqu'à une certaine manière les discriminations systémiques, l'oppression systémique. On ne le dira évidemment pas de cette manière-là, mais on va quand même reconnaître que certaines communautés vivent ou font face à des obstacles plus importants. Et dans cette mesure-là, on va proposer des réformes qui, justement, pourraient très bien être portées par des pro-choix, dont l'accès aux soins de santé et les congés parentaux payés, où ce n'est toujours pas le cas aux États-Unis. Et donc, ici, on a une directrice d'une organisation afro-américaine qui travaille justement auprès de ces communautés qui nous dit « Did it ever occur to us », donc les activistes pro-vie, donc anti-choix. That day, pro-choice activists look at Christians and they say pro-life, really? Black people traditionally have seen white evangelicals as pro-birth rather than pro-life because actions communicate that they don't care what happens to babies after, excusez, j'ai perdu le fil parce que j'ai vu le 2 minutes. And they don't mind seeing them shot in the back as soon as they get old enough to learn how to run away from them. Donc, on a vraiment cette dissension entre qui devrait porter la charge, finalement, des réformes pro-famille, entre guillemets. Et évidemment, il ne faut quand même pas l'oublier, ces personnes-là, même si elles militent pour des éléments qui peuvent nous apparaître intéressants, le font quand même dans une logique d'éradiquer l'avortement. En conclusion, pourquoi, d'un point de vue féministe, c'est pertinent ou intéressant d'étudier les tensions au sein des mouvements réactionnaires, conservateurs, antiféministes? Évidemment, je ne dis absolument pas que ma méthode de recherche, c'est la seule méthode de recherche valide et légitime. Je pense seulement qu'elle nous permet d'avoir accès et de développer des connaissances qui offrent une meilleure compréhension des réalités sociales qui existent, contrairement à cette perspective outsider où on a une vision très unifiée, très homogène du mouvement social. Et donc, pourquoi c'est intéressant pour nous d'avoir accès à ces données? Eh bien, ça nous permet d'ensuite adopter des stratégies qui sont beaucoup plus précises et beaucoup plus efficaces une fois qu'on a un portrait réaliste de la situation. Par exemple, ça peut nous permettre de viser des enjeux qui représentent des conflits au sein du mouvement et d'aller s'insérer au sein de ces interstices-là. Et on pourrait être surpris, en fait, de créer des coalitions avec des personnes avec qui on n'avait jamais pensé en créer. Et peut-être dernier mot là-dessus qui incarne peut-être un peu cette idée, c'est pour revenir sur les résultats référendaires sur les questions d'avortement le 5 novembre dernier. Donc, il y avait 11 référendums au sein de 10 États. 7 d'entre eux ont été remportés. Donc, c'était des propositions d'amendements constitutionnels qui garantissaient plus fermement le droit à l'avortement et les libertés reproductives de manière générale. Et donc, ce qu'on apprend là-dedans, c'est que parmi ces 10 États ou ces 11 mesures qui avaient été proposées, il y en a 7 qui ont été remportées du côté pro-choix. Et parmi ceux-là, il y en a 4 où le Parti républicain était largement majoritaire et a remporté les élections. Et donc, ça m'amène à vouloir dire que, ben oui, le Parti républicain, il est extrêmement campé sur la question de l'avortement, mais l'électorat, lui, beaucoup moins. Et on se retrouve, par exemple, avec un exemple au Montana, par exemple, où la mesure pro-choix a réussi à remporter 58% d'adhésion de la population, contrairement à Kamala Harris, qui a eu 38%. Donc, on se retrouve avec des républicains, en fait, qui votent en faveur du droit à l'avortement et pour la protection de ce droit. Et donc, je pense qu'il faut faire attention aux étiquettes qu'on pose aux gens et aux effets que ça peut créer éventuellement. Merci.
Oui, merci, Véronique. We're moving on to our third speaker on the panel this morning. We're going to hear from Kelly Gordon, who's an assistant professor in the Department of Political Science at McGill University. Her academic journey culminated in a PhD in political science from the University of Ottawa in 2018, leading to her current role at McGill. Her research focuses on conservative movements and politics in North America. She is also the co-author of The Changing Voice of the Anti-Abortion Movement, The Rise of Pro-Women Rhetoric in Canada and the United States, alongside Paul Surratt, which explores shifts in the rhetoric of the anti-abortion movement. Her work at McGill continues to delve into these complex political dynamics, contributing significant insights into contemporary political discourse. Her talk today is called Abortion Anarchy, the Case for Abortion Decriminalization.
Oh no, I can go. Okay. All my greatest fears are realized because I'm a political scientist that doesn't do the law and does politics, but I'm going to be talking about a law on a panel with somebody who obviously knows a great deal about the law. So it's my greatest fear and also exactly what I need in thinking about the questions that I've been thinking about. And so I think even though a lot of my research interests intersect with yours, the talk that I'm going to give today, I think exists perhaps in tension, but maybe not as much tension with Joanna's talk as well. So I'm also going to be talking about a little bit like, what does a good abortion law look like? And maybe, a good abortion law might look like no abortion law at all. So the context behind what I'm going to be presenting today is grounded in the fact that in virtually every country in the world, abortion is regulated by criminal law. even in regions where abortion is largely permitted and supported by law and public opinion and public institutions, there still exists criminal statutes that establish the permissible boundaries regarding who can access abortion, where it can be performed, when it's deemed legal, and how it should be carried out. I think that there's been, I mean, with the exception of this excellent talk that you just gave, less scholarship and also sort of activist conversations around abortion politics that's sort of considered the intricate connection between abortion and criminal law beyond the fundamental question of whether abortion should be criminally prohibited in the first place, right? So I think abortion activists have tended to fight abortion laws when they arise. Scholars have tended to focus on problems associated with criminal abortion restrictions, but rarely have we kind of put forward a vision of what an ideal abortion law might look like. And so I think that this work that you're doing is really important, right? But I want to think a little bit about how Canada, and I'm going to operate on the assumption that Canada has no abortion law, even though you've presented a compelling case that it perhaps does, what it might mean to regulate abortion outside of criminal law completely. And what I want to do today is present kind of a normative case for full abortion decriminalization based on Canada's unique experience with abortion decriminalization. And what I want to argue is that Canada actually represents the gold standard in abortion regulation, and that advocating for the Canadian model of abortion decriminalization, both in Canada and in other jurisdictions, offers abortion advocates a host of kind of strategic, political, and practical advantages. So, of course, the starting point here is the curious case of Canada. And what makes Canada curious is that for the past 30 plus years, Canada has existed as the only country in the world to have no criminal abortion laws. This has been the case since the 1988 Morgentaler decision. And so since then, right, abortion care has been not dictated by criminal law, but rather regulated like other healthcare procedures, right, under the standard accreditation and by the self-regulatory bodies responsible for the oversight of physicians. So I'm sure many of you know how we got here. I love teaching this history because I think it's very interesting. It's like sexy with like the tie vote in the Senate and like, so I don't want to sit here and be like smug, like Canadians designed this like perfect system and like, look at us. It happened by accident here. It continues to exist because of a host of socio-political and institutional reasons combined with high public opinion for abortion care. So there's no reason for us to be particularly smug. We got here by accident. But I want to argue that that accident has turned out to be a really good thing. And I think it's something that we can actively promote as the gold standard of abortion regulation. And so when I talk about this model of abortion decriminalization, what am I talking about? I'm kind of proposing a framework for abortion decriminalization that rests on two core objectives. One is the complete removal of abortion from the realm of criminal law, which would mean repealing any existing criminal abortion laws. And so this would mean that abortion care would be treated like other healthcare issues in the medical realm based on best practice guidelines, training, and delivery. And here I think we can think about the medical realm in a broad sense, right? That might include pharmacists, nurses, nurse practitioners, midwives, right? And so there's a few considerations that I want to kind of raise about this framework. I have 3 here because I took a 4th out, but I'm going to add it in. No, I didn't take, no, I did take it out. But I'm going to add it in to respond to the panel. So 1, I see this as a promising method for both regulating abortion, but also for advocating for abortion. So obviously, in a lot of places, this is unfeasible. We just need to look to our neighbors to the south, right? They're not going to be repealing all of their criminal abortion laws anytime soon. But I think advocating for this still presents strategic advantages. Second, I don't think that decriminalization alone can ensure universal abortion rights and access. Rather, this framework builds on the notion that emphasizing abortion access is more impactful than solely concentrating on legal reform without ensuring access. I'm going to add this one in, and I don't know how I feel about it yet. I'd like to have a conversation, so I'm just I'll add it in. This framework doesn't necessarily have to preclude any abortion criminal laws or criminal laws related to abortion. So, it might be compatible with what Joanna's talking about. We also can think of criminal offenses that are applicable to all medical procedures that might apply to sort of negligently performed abortion care or coerced abortions, right? So there might be some room for the criminal law. I don't know how I feel about that yet, so that's why I took it out of the presentation. And then finally, abortion decriminalization doesn't necessarily preclude the possibility of governments adopting proactive measures beyond the criminal law to safeguard abortion rights and ensure access. So we can think about governments addressing abortion through constitutional rights, like we saw in France this summer, or by implementing comprehensive public health services while operating under this framework, right? So this framework is not some panacea that guarantees abortion rights and access, but I see it as a productive starting point and potentially a minimum threshold for abortion governance. So I think one of the things that's been interesting is, especially in Canada, we've tended to focus as scholars and activists on the limitations of abortion decriminalization, and there are many, and I acknowledge those limitations, right? So as early as 1989, for instance, legal scholar Judy Fudge called the Morgenthaler decision a narrow victory and noted its failure to address systemic barriers to accessing safe abortion. And I think since then, a lot of really important work has tracked the way that this has proven to be true, right? And that access is unequal throughout the country. Both Joanna Erdman and Rachel Johnstone at Dalhousie have argued in different ways that decriminalization has legitimized the withdrawal of state responsibility. It's allowed for the privatization of abortion care in some cases and perpetuated inequalities, especially in the maritime provinces. And I completely agree with these critiques. Abortion decriminalization is not without limitations. No model of abortion governance is perfect. And I want to highlight two key limitations. One, decriminalization can leave abortion rights vulnerable, right? It doesn't establish or protect an abortion right. It's a negative action by nature, and so it risks leaving abortion vulnerable to further legal encroachment. Second, and I think maybe more notable in Canada, given how hard it is to get a family doctor, there are problems associated with treating abortion care as healthcare, right? Decriminalizing abortion means transferring control over access to the realm of healthcare. We know that healthcare is not some magical apolitical realm. And so in this way, the effects of this move are inherently tied to the nature of the healthcare system and the terms under which regulation is transferred, right? And decriminalization alone does not tackle this issue. But I would argue that these problems also exist in countries where there are abortion laws, even the most permissible abortion laws, right? They're not unique to abortion decriminalization. And I don't think these limitations are solved by criminal law. And I think that abortion decriminalization still provides opportunities to address and improve these issues in some ways, in ways that are more sort of effective than under criminalized models. So I want to finish by talking about, I have more, but 4 potential advantages of this framework. Oh, there are the limitations. It's okay, my PowerPoint is very basic and pathetic, so it doesn't really matter. All right. So first, it has proven to work, right? Canada, the Canadian experience has demonstrated that safe and ethical abortion care can be effectively regulated within the framework of healthcare without the need for criminal law. And I think under decriminalization, what we've also seen is progress. Maybe, this progress has been too slow for our liking, but we haven't seen the absence of a criminal law mean that we've descended into anarchy, right? We haven't seen any significant backsliding of abortion access since 1988, like in the US, for example. Rather, what we've seen under the framework of decriminalization is provinces have taken positive action to institutionalize pathways to abortion care. I think Quebec is the most standout example of this, right? Where developing and planning has taken place to ensure accessible surgical abortion care, and this history spans over 4 decades. But we've seen similar things across the country, and recently we've seen even New Brunswick agree to fund clinic-based abortion care. So it has worked in Canada. Second, I think that abortion decriminalization can provide strategic benefits for the abortion rights movement. So in Canada, I think there's good reason to believe that the lack of an abortion law has provided strategic benefits in at least 2 different ways. So one, Canadian activists have been able to focus their efforts on areas outside the law, like expanding funding and access. While activists in other countries have had to focus on really challenging criminal restrictions. And I mean, that's happened in Canada as well, but to a much lesser extent. That's a very expensive endeavor, right? And Canadian activists have had to focus on that sort of less, right? I also think it's diminished the impact of the anti-abortion movement in Canada in interesting ways. To your point, right, the anti-abortion movement is rhizomatic, it's divided, it's full of internal factions. One of my favorite things is to watch anti-abortion activists fight with each other, and they do. But in the United States, Roe v. Wade provided this target for the movement, right? They were able to coalesce around their opposition to Roe v. Wade. I think it's going to be really interesting to see what happens to the movement now and moving forward, because there are these huge internal factions. In Canada, there hasn't been that clear target for the movement, and that's meant that they're a bit of a mess. And there's certainly a movement that has been losing for the last 30 years in Canada. I also think that decriminalization can bypass some of the limits that we see in the law. So we know that abortion laws don't really work. Criminal restrictions have proven to be ineffective deterrents. And we know that they're dangerous, right? The criminalization of abortion consistently correlates with increased rates of maternal and infant mortality. We also know that, like other areas of criminal law, when abortion prohibitions are criminally enforced, they tend to be enforced in ways that are highly racist and discriminatory. So, we know that the law can hold symbolic significance and can shift the allocation of resources. I think Joanna made a compelling point for that. But criminal law always carries a risk of perpetuating violence, right? And even in the pursuit of abortion liberalization, legal measures, I think, can expose women, pregnant people, marginalized communities to heightened levels of legal scrutiny. And they can also shape broader political debates in ways that I think we don't want to go, right? And so, when I'm talking about the framework of abortion decriminalization, I'm not just talking about kind of removing abortion from criminal law. I think it's also part of this larger kind of shift that moves abortion advocacy in line with broader reproductive justice critiques of both the law and traditional pro-choice activism. I also think it can create opportunities to connect abortion advocacy with other social causes and build solidarity across movements. So for example, since 2020, we've seen the movement for Black Lives that's brought a renewed attention to penal abolitionism as part of the broader struggle for racial justice, right? And so I think for advocates of abortion access, advocating for abortion decriminalization can create kind of these opportunities to connect with abolitionist, anti-racist, and reproductive justice movements. And finally, I think we're actually already moving towards abortion decriminalization in a lot of ways. So in recent years, we've seen, Action Canada, for one, whose ED is here. We've seen global health authorities like the World Health Organization and the International Federation of Gynecology and Obstetrics take a strong stance on this. They've started advocating for the decriminalization of abortion. We've also seen some countries like Australia and New Zealand starting to adopt kind of hybrid models of abortion decriminalization. And I also think this shift makes sense when we look at how abortion care is evolving today, right? Particularly with the rise of self-managed abortion cares, with the sort of increased use of mifepristone and abortion pills throughout the world. And so I think, in some ways, this shift is already happening. And so thinking about how to kind of explicitly make the case for this shift is something that we should be doing. And then just a final thought, because I'm not a lawyer and I don't really know about the law, is, I've been thinking about abortion decriminalization for a couple of years, but I've also been thinking about whether making a case for kind of decriminalization of reproduction more largely is something that we should be thinking about. And I think that this is the room maybe to have these conversations. So, I'd like to hear from people working on sort of surrogacy, egg donorship, those kinds of things about what conversations are happening around decriminalization or sort of the role of criminal law. Thank you very much.
I think your slides were pithy and streamlined and fantastic. Thank you for a great presentation. Lots of great threads connecting all three of the presentations so far. Our final presentation on this panel this morning is Elena Caruso, who's a postdoctoral fellow at the University of Waterloo's Department of Political Science and a fellow of the International Reproductive and Sexual Health Law Program at the University of Toronto Faculty of Law. She holds an MA in Law from the University of Catania and an LLM in International Law and a PhD in Law from the University of Kent. Elena's academic expertise spans legal studies, gender equality, empirical legal methods, social movements, reproduction, and legal history. Her current research projects include an exploration of how self-managed abortion practices challenge traditional medical legal frameworks and an analysis of the feminist movement's role in the legalization of abortion in the 1970s in Italy. Elena has a rich research experience through visiting fellowships at a variety of schools in Europe. And she spent a semester at the University of Bonn Law School as an Erasmus student. We're going to hear from Elena presenting her piece this morning, which is what is a good regulation of abortion.
So it's interesting that we were thinking in the similar lines. So of course, the end of the constitutional protection of abortion rights has created and has catalyzed a debate about the regulation of abortion, also in place where this was supposed to be a more silent and less hot topic. And so I've been thinking lately around what is a good regulation of abortion. And this morning, I was talking with Professor Erdman about Canada and New Zealand that for me provided two different models that are very interesting to look at. And especially because around the world in so many places, there is at the moment a debate. For example, in Scotland, there is a review at the moment about abortion. So these conversations are quite timely. So what can be my contribution in this conversation? Luckily, I decided to not do a paper on Canada because I would be not able with you to say anything more. So I decided to go to my little niche, which is history, and this is the history of feminism and abortion in the 1970s, and what this history can tell us, can contribute to this conversation. I very much like to go back to history to see how people think of similar things in a different way. So this paper draws upon extensive archival research and oral history interview that I conducted when I was at Kent Law School in England between 2019 and 2023. I'm now in the process of turning this research into a monograph, and the paper that I'm presenting is going to be probably one of the chapters. And the story I'm going to talk about specifically is about a specific bill, one of the 17 abortion bills that were submitted and debated in the Chamber of Deputies at the Italian Parliament between 1971 and 1978. Italy, I don't know how many of you are aware, surprisingly, has an abortion law in the more conventional way, not in the unconventional, cool Canadian way. So we have just a law that is called basically abortion law. That is a law of 1978. And the approval of this law followed followed years of feminist campaigns for free and safe abortion on demand. In mid-1970s, abortion became a specific important topic. Like today, we say, it was a hot topic in mid-70s in Italy as well. And it was virtually an important topic in the political agenda of virtually all the political parties. And at that time, Italy still had a near criminal abortion ban, more similar to the one that in Canada that was before 1969, that was part of a framework of crimes called crimes against the integrity of health and race, and was a bunch of crimes that were created during fascism in 1930 and outlived the fall of the regime. So what happened in the first part of the 70s is that the Italian Constitutional Court started to say these crimes don't comply with the Italian Constitution of 1948. So at some point we had our, let's say, kind of Morgenthaler or Roe versus Wade in 1975, and Parliament was forced to take the matter in its own hands. So the story that I'm going to tell you is a kind of response to this background. The Italian feminism was campaigning for free and safe abortion on demand, and contextually, while waiting for this ideal framework, working to secure right now a route to safe abortion to people that needed one. One route was to go to England, where abortion was already partially legalized with Abortion Act 1967. And the second route was the creation of self-managed abortion groups, which operated illegally and operated through the use of the vacuum aspiration technique. You can see a picture about it that is also known as the Karman method and consists of the sucking of the contents of the uterus through a flexible cannula. This is of the technique I can talk about more. Was very important for the Italian feminism. They hated the idea of the carottage, which, for example, was practiced in American groups, for example, the Janes in Chicago. So this feminist mobilization in Italy contributed to make the Italian feminist movement a main protagonist of the abortion campaigns and debate. So the Italian feminism as a whole was very critical. They didn't like, as the Canadians today, they didn't like the debates about abortion bills debated in Parliament. So at some point, a part of this feminist movement, some strands of it, decided to take the matter in their own hands and propose their own abortion bill. One of these feminist campaigners commented on this initiative. This is not a bill. We do not delegate to any political party the right to present a law by or for women, but we believe we can continue the conversation until we arrive at a proposal which is not theoretical, but comes from our work, from the movement. We will not be willing to negotiate our proposal, neither in form nor in content. This person, Simonetta Tosi, was a prominent activist in Rome. She was also a medical doctor, and she was very active in Rome. And so she was really behind both the abortion travel organization and a self-managed abortion practice in Rome specifically. However, quite soon, a position like the one of Simonetta Tosi was absolutely not representative at all of what were the thoughts about this topic within the feminist movement. So there were at least 3 meetings to discuss this feminist abortion bill in Rome, Milan, Prato between September and October 1978. And there were 3 main positions. One that we say was more institutional, led by a group from Turin, who proposed to incorporate this feminist knowledge and experience in abortion travel, self-managed abortion into a proper bill, a formal bill, through the support of sympathetic MPs. So according to this feminist from Turin, we don't want to delegate the drafting of a law for women to anyone. We want a law for the women, from the women of the movement. A second position was more bound to separatism, which was the practice of staying only among women, and autonomy, so political autonomy of the feminist movement from political parties and organizations. So this fraction disagreed with any direct involvement in the parliamentary process, deeming this approach too much extraneous to the feminist practice. So this part of the feminist movement agreed to just increase pressure on the parliamentary debate from outside, so continuing rallying outside in the street, campaigning for free and safe abortion on demand, and just continue to exercise pressure from outside. A third medium position was to work for a so-called People's Legislative Initiative, which is a possibility that is included in the Italian Constitution. So if you collect enough signatures, you can propose the bill into the Italian Parliament. So this position was a medium position because still there was a certain level of engagement with the formal institutions, but the feminist movement maintained at least a political autonomy from a specific political party and MP. But still, there was a lack of unity within the feminist movement around this topic, as I said. So at some point, the pro-law, let's say, strand led by the Torino people, feminists, decided to pursue alone their project for a feminist abortion law. And so with the support of two men from a far left group, one of them was Mimmo Pinto, who I interviewed, and he told me this, remembering that experience. We were the vehicle, but this was not to distance ourselves from that legislative proposal. We were rented at that time. This was a women's law, and we brought it to the parliament. I didn't see this as a limitation. Instead, I was very happy that some comrades had asked me to work on the law with them. However, a few months later, in December of the same year, so Italians argue a lot, a group of feminists from Milan remarked once again that this bill does not represent the entire movement. They were very upset with the Turin and people that did this initiative. So they write this document, et cetera, et cetera. So it's a very complex document, but in short, they disagree. They, of course, agree that abortion should be decriminalized, like there should be no criminal law on abortion, but they disagree about providing any direct support for the legal regulation of abortion. So for them, there was a contradiction to claim on one side the self-determination, and on the other side, they rely on the state to regulate this. So according to these feminists, supporting this bill means to work inside the alienation rather than for the liberation from it. But another aspect that was very interesting about this bill was the content. So there was a tension about how to translate our feminist claims, which is a point that you always make, how we can translate what we desire being an abortion into concrete legal norms. There is a tension. So some feminists from Rome express this tension. The contradiction with the law has broken out. Putting ourselves in a parliamentary law perspective has meant either to attempt to force feminism under legal form by not allowing any compromise in the name of purity or sacrificing a part of our agenda. At the end of this final bill, at the 19 articles, Article 1 said the abortion at women's demand is not a crime, et cetera, and the bill included very original and radical provisions, such as a full decriminalization without the gestational age limits, legalization of self-managed abortion, legislative recognition of the woman's decision regarding the abortion technique that, as I said, it was very important for the Italians, and the introduction of an ad hoc abortion leave. The turning point was this one of the gestational age limits, the fact that there was no provision of a limitation. And so this is why Elena Bertocelli from Milan remember how to justify this provision. This is why, as feminists, we don't feel able to use the concept of punishment in a law that proclaims itself in favor of women. Our starting point is that all women are responsible human beings, and that for each of them, abortion is a dramatic and heavy choice, a bit of stigmatizing. We do not accept that we can be considered as second-class citizens who, in order to solve a problem, must submit to the decisions of those who legislate on our skin. And another feminist, always Simonetta Tosi, said that we disagree that only specific circumstances could ground abortion access. We absolutely don't believe that a woman has a late abortion due to her negligence, but it's because abortion is still not accessible. So, but retrospectively, when I interview some of these people, like Laura Scima, who was at Turin, is a feminist in Turin still today, and I talk with her retrospectively about, she was in the forefront of this abortion bill. She said that retrospectively, she didn't like that. I consider that a little bit extreme because basically this bill admitted, in her words, an infanticide. And also talking with Mimmo Pinto, one of the MPs, about like this turning point of the gestational age limits, he said, yeah, that was the first point in my opinion, but it was not in the measure in which you wrote that the final word, the decision must be the woman's one, her decision. It was strong, perhaps looked like a law of extermination, but it was not, because it said that it was the woman's who must decide. So these 2 points of the full decriminalization and the lack of gestational age limits were very progressive. Also, if we see retrospectively, in my opinion, this story, if we think that, for example, the World Health Organization includes recommendation on full decriminalization, although we don't know what it really means, and against the gestational age limits. So I think in conclusion is very, I mean, at least for me, exploring the feminist genesis of this specific abortion bill, and also gives us a sense of when we talk about these questions, and for example, the critique of law that is been expressed by the Canadians when they say that they don't want to enshrine abortion in any law, how this position is built in a different, for example, argument compared with the Italians, where the skepticism for the law was a skepticism for the state. It was not about citizenship. It was more part of a strong skepticism for state institution and in general politics of legal reform. The second reason why, of course, I think this bill is very interesting is because of this conversation about gestational age limits, which in my experience is very difficult to have also among pro-abortion people today. So that's my contribution. Thank you for the attention.
Thanks very much to all of our speakers. We are at 20 after 10, and we have until 10:45. We can take questions. So if you have a question or a comment, maybe join us here at the microphone. Thank you. Go ahead.
Okay, thank you. Thank you, everyone. This is super interesting, and it's always really exciting to be in these spaces. So I have a question, sort of to get your thoughts, everyone on the panel, on this question of decriminalization and how it can be used as an advocacy tool. So I'm completely of the position that decriminalization is the gold standard for regulating abortion. However, in terms of how we use that as an advocacy tool in international spaces, I think requires some thinking, because the work I've done in international spaces where we're really advocating for decriminalization, it's hard to point to Canada as this great example when, particularly in times before medical abortion was easily accessible here. It's hard to use that as an advocacy tool, like, look at Canada, while you're talking to people who have much greater access to abortion than Canadians. Particularly as someone from the Maritimes, it was hard to really point to Canada as this great example that should be followed. However, I think so in international spaces, it is advocated for, but it's almost, how is it useful as a tool for advocacy? Like, who is the audience of that advocacy? So amongst abortion rights activists, we don't need to usually convince each other about decriminalization, but you have to convince policymakers, politicians. And I almost think that it's useful in a tool of like, you can decriminalize things and not necessarily change everything. It can help alleviate that fear. And so like a couple of things that I think are useful for that is this idea of addressing the chilling effect for physicians and other medical providers, and that you have many examples where you have any sort of limitation, you have this chilling effect on providers, and they're not sure, is this within the boundaries? Is this medical emergency? Does this qualify? Does this not qualify? And it creates a chilling effect. And so you look to address that, saying decriminalization is a method to address this. also the criminalization of women. So I think in the UK in particular, you've had a couple of like horrific cases where because of the law, which even though access was pretty good in most of the UK, the law was not great. That was exploited, and you had prosecution of women for self-managed abortion. And that has really triggered a lot of people to say, oh, actually, maybe we should be looking at decriminalization. So it's almost as if the way we use decriminalization as an advocacy tool is maybe pointing out that it doesn't necessarily create dramatic changes, but it can address like these specific problems that even within anti-abortion movements, there's a lot of people who are on board with. Thanks.
So I think it's a great question and really exciting on a panel, because when was the last time you were at a panel where there was like a genuine question on the table versus people just agreeing with each other and saying, yeah. And I'll tell you, this project came from the place of traveling, because it tests your ideas when you need to articulate them in different places. And in Latin America, where there is undeniable social and structural inequality, the idea of decriminalization and the state walking away and public resources means something very different for people. And they are really alive to this idea. Is that what you're talking about? Yeah. So here I think this idea for me, how I came to it was, and I'll say absolutely decriminalization, not contesting remotely. Decriminalization is absolute. And I also would not advise legalization of abortion. No, absolute. But the question is the one you asked, I think. What is decriminalization? What is decriminalization? And I think you phrased it really nicely, which is it only a negative action? Is it only a negative action? And that's where I've come to a different position. Because I think decriminalization is actually the undoing of all of the effects of criminalization. And that may require affirmative measures, yeah, including all the effects of criminalization. I'm a health law scholar on the healthcare system. So for example, right now, you have extraordinary advocacy work around expanding the scope of practice for midwives to be able to provide abortion care. Midwives did provide abortion care. That was a feature of the criminalization of abortion, which was to de-skill so many health providers in community settings. And so for me, that's a part of decriminalization, is to now expand the scope of midwifery practice to be able to provide the care that, frankly, they could always provide. They could always provide. It was only an effect of criminal law. So I do think this moment is a moment for feminist engagement, with law. Like, I agree, in Canada, it's striking because the claim "we need a law" has always been the phrase of the anti-abortion movement. So it's a kind of tough moment to think about. And it's my discomfort with zoning laws because of their kind of root in police power. But there is really nice critical scholarship about zoning, which is not about the separation of use, but about the making of place. And again, I think this way of being much more critical in engagements with law could potentially be helpful. And again, these laws in the 1990s, everybody wants to stop at Morgentaler. And when you move internationally, it's like, tell us about Morgentaler, because that was the moment of decriminalization in Canada. And I want to say, no, decriminalization was then the decades after, including in the 90s, when these provincial governments, not all of them, but those zoning laws were also part of public funding for clinic services. They were doing all kinds of things to unravel the effects of the criminal law. And I'll just put this out too. I think, at the federal level, it was kind of fascinating. Like when Trudeau offered an abortion rights law, my position would have been like, well, I won't take that one, but can I have this one? It's like, what else could have been on offer? People said, like, how? Where are you going to legislate out of as the federal government? All of us would have said you can't do it out of the criminal power. Absolutely, because decriminalization. But then the question is, what other federal powers are there? It's so interesting. Again, abortion rights activists, an abortion law they will always name is the Canada Health Act. That's a spending statute. That's about public resources So again, it's really interesting in thinking about a federal law that was a reproductive justice law, what that would look like about, again, this architecture of social and economic and care policy. Again, I think rooted in reproduction, keeping and putting abortion as part of comprehensive care. So I think that's the kind of Canadian story that maybe is a different story than the kind of Morgenthaler and decriminalization. Yeah. Yeah.
Yeah, very happy to be having this conversation with you because I need to have them because I have all of the same questions of like, what else can the law do, you know? But, you know, I think that I think thinking about this for me actually came like after Roe and having conversations with media and others, where people in Canada, I think, so your question was about the international, and I'm going to talk about it in Canada because it's what I know about. But there's like, the conversations that we have about abortion care are so seeped in sort of a negative affect, right? That we have these gaps and like, what about New Brunswick? And like, and I think it's a story, and I understand why we tell that story because we look to our neighbors and we're like, look what can happen, but that's not our story, right? I think that the story that Joanna is telling is much more our story here. And I think one of the effects of telling this story over and over about how decriminalization just led to this mess where people can't access abortion care, it silos abortion off from larger healthcare and reproductive healthcare issues, right? So, I mean, I think the reality, I don't know if there's people that would disagree, is that it's harder to find a family doctor in Canada than it is to access abortion care, right? And so by sort of taking abortion out of these conversations about maybe it's not a problem with abortion care, but it's actually a problem with healthcare, the ways that we fund it, it's a problem with the Canada Health Act, right? I think that the lens of decriminalization allows us to have these different conversations that I think are really important to have, including and like, this is where I am interested in having a conversation about your wariness around zoning laws or public nuisance laws, which historically have been incredibly punitive and oppressive and discriminatory, right? Is this wariness of the criminal law, or this kind of belief that the criminal law can somehow deliver liberation, or, you know, and so, I mean, you're talking me think a lot about that. Also, I used to work at an abortion clinic, so I used to take the injunction and go out there, like wave it at the protesters. And that was great. But now that I'm sort of situated differently, I'm like, do I believe in a criminal law against protest? Like, I don't know, right? So I mean, I'm grappling with these questions and thinking about this as well. And those are just like a bunch of thoughts that don't really have a thread, but.
Peut-être juste pour faire du pouce sur ce que Joanna a dit, je suis vraiment d'accord que la décriminalisation, c'est un point de départ et non pas une fin en soi. Et peut-être un exemple au Québec en ce moment. Bon, déjà, la semaine dernière, il y avait justement la loi sur l'accès qui était contestée devant les tribunaux. Donc, on est là-dedans en ce moment. On attend la décision, même si on n'est pas trop inquiète. Mais surtout, depuis 1 an et demi, donc les activistes, les militantes et les gens impliqués dans l'université comme nous ont milité très fortement auprès du gouvernement du Québec pour décourager l'adoption d'une loi. Donc, au Québec aussi, on avait cette idée qui a été mise de l'avant depuis 1 an et demi. On est parvenu à convaincre le gouvernement du fait que c'était une mauvaise idée. Et donc, pour moi, quel genre de politique est une bonne politique? Ce n'est pas une loi, mais c'est le plan d'action sur lequel ça a débouché, qui a été lancé cette semaine, qui est le premier plan d'action gouvernemental sur l'accès à l'avortement de l'histoire du Québec. Et donc, là-dedans, on retrouve 28 mesures qui vont permettre de combattre la désinformation, d'étendre l'accès, avoir davantage de points de service. Et donc, pour moi, c'est peut-être le point de la décriminalisation, c'est de mener à ce genre d'initiative. C'est ce que ça permet finalement.
Merci.
Fact that you don't have a specific abortion crimes leave out a problem from the conversation. Thinking of England, where there is an increment of the use of this like Victorian legislation, criminal legislation, and so I understand, of course, that if you're in Canada, you can see that there are issues around access. But the fact why Canada is so special also for people that are not Canadians like myself is because unfortunately, the way in which abortion access operates in the West, even in places that are considered liberal, that on the map of WHO or Center for Reproductive Rights look like they have abortion on demand, abortion access is very difficult. So the fact that Canada, with all its issues, is a good law speaks volume of how difficult the situation is elsewhere. So this is not for fetishize what the Canadians are doing, but the fact that you are already put the conversation out, that you can have today the luxury to talk about what is decriminalization. This is not a question in Europe. We know what is decriminalization because we have still abortion in the criminal law, which is abortion crimes clearly. So we don't have even this problem of definition because we have already criminal law abortion crimes affecting our bodies and in a very clear way. So even this is not an accident that this question of the definition of decriminalization is a question that I start thinking about since I'm here in Canada. It was not a problem for me. What is decriminalization when I was in England? It was very clear to me, the answer to that question. So that is probably my contribution to this question about decriminalization, Canada is good or not, etc.
Thank you so much for this remarkable panel. I have a question for Professor Erdman regarding, thank you so much for bringing out the compelling argument that there is the world of law beyond criminalization and criminal law, and how we need to look at jurisprudence, especially as Canada is leading the argument about looking at positive rights and negative rights within this framework of the law. How do we regulate abortion? My specific question is regarding graphic anti-abortion imagery and the freedom of speech and expression. So as you may be aware, St. Catharines did bring in a bylaw regulating graphic anti-abortion imagery, but it withdrew it because there was a challenge on the fundamental argument that freedom of speech and regulation of literature. So it's a charter challenge. Do you think it will be a charter challenge eventually in the court? It will lead to this argument of having a charter challenge, and if it does become a charter challenge, do you think it will pass the Oakes test? And in which aspect, if it does fail, which aspect of the Oakes test will it fail in terms of meeting the requirement of freedom of speech?
Yeah, you're right. There's this really fascinating body of case law that people aren't writing up or taking note of, which is at the municipal level. And so, as I mentioned, a bunch of challenges around public advertising on city buses, around protest activity outside of high schools, not clinics, use and even campus speech. Also, I mean, I think it's fascinating because, again, it's intersecting abortion rights with these rights of public protest, with these rights of public space. And I think we should and absolutely keep our eyes on these cases because they're really important ways of understanding what indeed is reproductive freedom and liberty in ways I think that don't make us uncomfortable in the ways in which we understand liberty more generally or freedom more generally. So one of the cases, I'm trying to remember the Ontario city in which it is, the crafting of bylaws got so confused. They got so kind of upset with the charter arguments around freedom of expression and having content specific restrictions that they sort of just said, like, you know what, let's just restrict like all protest signs. And the abortion rights activists were like, no, that's not what we mean. But I think the moment here was to position something counter, like what is then the government objective here? Do you know, and this idea of a right to space, a right to use and enjoyment of space, I think is something different. Do you know what I mean? Yes. It's kind of a positive entitlement rather than a police power, rather than a negative, and trying to build that out as something. And I think it's rooted in gender-based violence, understanding reproductive violence as related to this activity is a real avenue that I think governments don't have yet. And don't have a way of expressing that in these cases. So to your question on Section 1, that will be really important. And it's also important not to totally base it on protection of the vulnerable. I think also that's a very dangerous argument to make. And so being able to articulate, I really like this idea of, you know, the ability to access, to use, to the enjoyment. And what is that to craft and to make a certain kind of place, including for reproductive care? Because that's really in care politics, not just care in a clinic, but I think care politics as indeed public policy. So for me, that would be, yeah, a kind of advocacy agenda, because I think you're right. As soon as it gets into public space, I think the arguments are different than protecting medical care in a medical clinic. Yeah.
Thank you so much.
Okay. Thank you so much for this amazing panel. In thinking about decriminalization, the first things that come to mind for me are some of the efforts around sex work and marijuana. There's sort of various other kinds of decriminalization. I was just wondering if any of you are thinking with or kind of looking comparatively at these other efforts to decriminalize things, and if there are you know, lessons to be learned, cautionary tales, so kind of a comparative question.
Yeah, like I'm writing a book on something completely different, so I'm trying to finish that. But when I started thinking about this, I went searching for this literature, and there's a lot of literature on sort of decriminalization and sex work specifically. But what surprised me was that there's not much in sort of like theories of decriminalization in relation to like reproduction or sex work, or sort of like questions that intersect with gender. So there's like this, you know, like high level theory that talks about the law, right? And then there's like policy specific things about, you know, the decriminalization of sex work, but this work sort of in between, I haven't found it. If somebody knows where it is, let me know. So the question is, or the answer is yes, I was thinking about these things, and actually, and maybe I'm going to in the future. I have other things, but and that's why the last slide was like, sort of, is decriminalization a model that we can think about that applies to kind of different areas and can kind of bring us together? And then I had something else to say, but I think that's what I think about. That's my hesitation when I think about public nuisance and zoning laws, is the ways that they've been used against sex workers, right? So I think there are interesting conversations to have across these. Anyway, I don't know if that, I mean, I imagine that's something you thought about.
No, I mean, I think the idea here is the form and the content of law. Do you know, like, this is my point. Like, in the end, they use this, and I think in the 90s, it's very different, you know, than the current context. But that's why that case law is quite interesting, because they're trying to run a public interest through a form of law, which I think the reason why those cases are so difficult is because they don't quite match. Like, it's really interesting. They're trying to articulate what is the public interest here, and it's not the same one that usually runs with zoning statutes. But they're using the form of the zoning statute to run this public project that is more liberatory, creative, expansive. That's what they're trying to do, rooted in care politics. Do you see what I mean? And so I think it's a really interesting moment to try and move governments away from zoning statutes, move them away from police powers, but be able to do it by holding on to this continuity of the nature of abortion rights in public spaces that is rooted in a care politics, not in a zoning logic. Yeah. If that makes sense. Yeah.
Hello, my name is Michelle Giroux. I'm with the Faculty of Law, Civil Law section at the University of Ottawa. Thank you for this amazing start of the conference. I have two small questions. Joanna, I wonder if you could comment, you know, the impact that not the impact, but the effect or that could have this constitutional contestation right now in Quebec that Véronique talked about very briefly. And it's all in, je vais le dire en français, I'm going to say it in French. C'est tout dans la mouvance, finalement, de l'impact que pourra avoir le mouvement américain de remise en question du droit à l'avortement, etc. Et la seconde question que je me pose, c'est concernant la question posée par Kelly, concernant la façon dont on peut imaginer l'encadrement ou enfin meilleur accès à la justice dans le contexte d'une décriminalisation. Et Joanna parlait de l'impact important, par exemple, de la loi Canada Health Act. En même temps, je ne peux pas m'empêcher de penser à la loi sur la reproduction de 2004 qui a été finalement déclarée inconstitutionnelle en partie par la Cour suprême du Canada. Alors, comment dans la Fédération canadienne, au-delà du Canada Health Act, qui est une loi finalement de dépenses, finalement, qui porte sur le pouvoir de dépenser, comment on peut réellement s'assurer que dans la Fédération canadienne, on va bien aménager l'accès à l'avortement, puis les soins de santé. Puis, pour faire un lien avec la question précédente, moi, j'ai été impliquée un peu dans le contexte de l'aide médicale à mourir au Québec et c'est une autre belle analogie, à savoir la décriminalisation. On a situé au Québec, dans un contexte de continuum de soins, l'importance de prévoir l'aide médicale à mourir comme un soin de santé, ce qui peut entraîner toutes sortes de conséquences et des statistiques très élevées potentiellement, des contestations aussi intenses, mais je me demande comment, dans le fond, pour bien organiser la Constitution canadienne de façon efficace, au-delà de la loi canadienne sur la santé, quelle est votre perspective à cet égard?
Ou peut-être pour toi, si vous avez des idées, parce que c'est ça, ouais, mon expertise est vraiment en politique, alors je commence juste à penser à ces questions de régulation hors le domaine de la loi criminelle. Alors, c'est peut-être de vous demander la question.
Je trouve que c'est toujours difficile de trouver la solution dans la Fédération canadienne avec le partage des compétences.
Mais c'est ça.
Puis plus dire, ben, il y a des fonds, mais finalement, ce sont les provinces qui sont responsables en matière de soins. Donc, comment réellement il y a une discussion fédérale, provinciale, territoriale pour vraiment mener au-delà du financement à des réelles solutions finalement?
Mais je pense je commence juste à commencer à ces questions et je pense que mon intervention, c'est vraiment que peut-être comme que le domaine de droit, c'est pas le seul domaine d'avoir ces conversations-là.
Non, ça, c'est certain.
On doit imaginer l'avortement, des autres enjeux, mais c'est comme dans des différents domaines. Mais je pense que quand on parle de l'avortement, il y a cette assumption, cette assumption que c'est vraiment, ça reste dans le domaine de loi. Alors, I think, je veux comme, I want to disrupt that a little bit. Je veux...
Mais si je peux me permettre, je pense que vous le faites très bien.
Ah, c'est gentil.
Mais il faudrait être plus... Vous le faites d'une façon exceptionnellement brillante. Donc, bravo. Mais Joanna, what about also the impact of, the first question about the contestation of the constitutionalization of the restriction of the manifestation in front of the clinics that are in front of the Superior Court of Quebec right now? Thank you.
Yeah, I think it will be an extraordinarily important case to see the reasoning in 2023 as compared to 1996. I think this is a really important moment because it might reflect this changing set of political ideas that are behind these laws that reflect this mismatch between their form or their kind of histories as zoning laws and the intention behind them, or they might indeed repeat some of that old kind of logic taken from the form. But I think being able, and I don't know who were interveners in the case or how that worked, but I think this will be a really important moment to re-articulate. And in making new abortion laws, the idea would be to shift from this kind of restrictive understanding to the way of building out supportive frameworks that are just expansive in scope. So that's why I think I started with the idea like they're anachronistic. They don't work anymore. What's an abortion zone anymore? You couldn't zone right now the points of care on abortion. There's thousands of them, and most of them are private homes. Like you just couldn't. Even the terms of the statutes don't make sense anymore of public and private space because they're so moving. So they're just not functioning as zoning laws anymore in that way. There aren't abortion access zones. So then what's the public interest behind them that could justify it, and being able to articulate that and finding new form would be an interesting one. And I do think the Canada Health Act as a legislated form, and spending power is a very different orientation to state power, becomes quite interesting for abortion rights activists. And quite frankly, again, the budget measures that governments have taken in recent years have been some of the most critical points for guaranteeing access in this country. And I definitely share that globally to say, like, get your funding, get it into your budgets, get it into government budgets. That's going to matter for access to care. Yeah.
I'm really sorry to draw the conversation to a close. Should I take the last question or? Okay, sure. Yeah, go ahead. And then we'll have one last question, and then we're going to have to wrap up this fantastic conversation. Go ahead.
Thank you. Effectivement, la contestation qui a lieu en ce moment devant les tribunaux, devant la Cour supérieure, c'est une contestation qui date déjà de plusieurs années. Ça fait extrêmement longtemps qu'ils attendaient ce moment d'arriver au procès. Le procès s'est déroulé sur une période beaucoup plus courte que ce qui était anticipé pour plusieurs raisons dont on pourra peut-être parler davantage dans les conversations privées, mais on n'est pas tellement inquiète du résultat de cette contestation. Cela dit, ce que ça nous dit, ce recours, c'est cette logique de conflictualisation de l'enjeu de l'avortement, d'amener ça, de judiciariser l'enjeu. C'est quelque chose qu'on voit encore énormément aux États-Unis, qu'on voit importer ici. Et je suis beaucoup plus inquiète de prochains projets de loi, et j'ai très hâte d'en parler avec Frédéric d'ailleurs. Donc, il y a un projet de loi au fédéral en ce moment qui a été annoncé, qui n'est pas encore déposé, mais qui viserait à restreindre l'octroi du statut d'organisme de bienfaisance aux organismes qui parlent d'avortement dans la manière dont il faut parler d'avortement, soi-disant. Et donc, moi, j'ai beaucoup plus d'inquiétude par rapport à ce type de projets de loi qui ont l'air de bonnes idées, effectivement, parce qu'on veut forcer les groupes à parler d'avortement d'une manière qui est neutre, qui est médicalement correcte, mais qui va mener à une judiciarisation encore plus grande de l'enjeu de l'avortement. Et qui va, si on regarde ce qui s'est passé aux États-Unis, et je suis consciente qu'on n'a pas le même cadre législatif ou judiciaire ici, mais qui va mener à des décisions où on va notamment mobiliser la liberté d'expression et où ça va aboutir sur des décisions de la Cour qui vont octroyer des droits finalement à ces groupes contre l'avortement. Donc ça m'inquiète beaucoup plus que la contestation qu'il y a au Québec en ce moment.
Thank you to everyone on the panel. Two quick questions to Joanna mostly. We usually privately seek your advice on legal positions, but here you go, I'll do it publicly. So there's the case Klubakov in front of the Supreme Court right now. And in listening to the arguments last week, is Action Canada as an intervener in it, where we draw the link between abortion and sex work. So to build on the sex work question, I was listening to the attorney generals from several provinces make the argument that policy directions is Parliament's realm, and the court should be limited in terms of their ruling in not changing the scope of a policy decision. So in the case of the government of Canada having decided that sex work should be abolished, the court should not go beyond that. So I see that as a risk for abortion. So if we have a government that comes in and says, well, now the policy direction is that we outlaw abortion, how is that possible that this argument is being made that the courts would not have any kind of grounds for challenges there? So that's my first question. Second question, to speak to
other tools that can be used to curb abortion access or rights. The use of the notwithstanding clause by Saskatchewan recently, I see that personally as maybe the biggest risk to abortion in Canada. Do you agree? Do you have any comments on this and recommendation in terms of how to articulate that argument? Thanks.
I mean, it's really interesting, your question. It's a little funny because it's like, if decriminalization means to disengage with law, it might be a dangerous position because that means you leave it to governments to defend. And they're not always in the best position to do so, do you know? And it becomes a very difficult moment when it's a policy position that you'd agree with, but you can see the legal argumentation, the logic of it is something you absolutely refuse. And so again, I think on this, it's this way of articulating a different public interest. It's articulating an entirely different way of understanding state power in abortion rights that we need to make so that when governments come to defend action on this policy position, you know, they don't resort, right, to claims that are, I think that I couldn't defend at all, and I wouldn't want to defend or understand it that way. So abortion rights in the service of state power is not the orientation. And I think that's exactly the presentation of the feminists in Italy. Do you know, when they refuse that? And so there's a completely different way, of orienting abortion rights to state power. And that's, I think, the work of legal engagement today. And I also think it's the way that it's going to make Canada most protective against a policy shift. So for me, it is decentralization of care, absolutely, completely undo all the effects of criminal control, which were about controlling, and therefore you make the system uncontrollable in some way. Only support, not control. If that is your status quo, I think it's the best protection against a restrictive action, because you're literally going to have to target all of those places. That's why the US fell as quickly as it did, because Roe was the linchpin and it held it together. And once gone, there goes everything. And I think the Canadian scene could be very different than that. Yeah.
I think that's political suicide for any conservative politician anywhere. Like, even in Alberta, you don't see Danielle Smith taking up abortion. She's just going after trans kids instead, right? I think that there's sort of like institutional questions of public, I mean, we've had these conversations before, right? Questions of just really high levels of public support for abortion care that mean that, I mean, on paper, it would be so easy for a majority government, I mean, and then you talk about what the Supreme Court would do and all of these things, but to criminalize abortion in a stroke of a pen, like in some ways, Donald Trump wishes that he had that kind of power, although he almost has it now, right? But I think there's really sort of strong norms against that, right? So I think we should be worried about its invocation in other contexts, but not in relation to abortion. And I think by continuing to focus on the abortion issue, I think sometimes we obscure the other things that conservative governments are doing at the provincial level.